Friends, welcome to Green Card Guys TV. I'm your host, John Ting. I practice immigration law in all 50 states of America and across the world. We help clients live and work in America legally. Today, we're going to talk about 3 things that President Trump is trying to do to implement right before he leaves office in January 2021. Now, you want to watch all the way until the end because this could affect you or your family members. Now, here's a second thing that President Trump has done through, through the Department of Justice. Many people don't know that the immigration courts, which we call Executive Office of Immigration Review, is housed under the authority of the Department of Justice. So you might remember that under Jeff Sessions, a lot of things were happening where the judges were not allowed to temporarily close the cases, which we call administrative closure. And also that judges had to have potentially up to 4 court trials in one day. So for example, if it started at 8:30, then there's going to be another one at 10:30. And then if there's one at 1 o'clock, then there's going to be another one about 3 or 3:30. So that's a jam-packed day for any judge, let alone immigration judge. And usually it'd be, if anything, 2 per day, 1 in the morning and 1 afternoon. So those are the 2 main things that Jeff Sessions instituted during his time. Now there's a new rule that the Justice Department is requiring judges to ask for relief, basically evidence that an immigrant who has a court hearing that is eligible for any kind of relief. And that has to be filed within 3 to 4 weeks of their court date. Now, to some of you to some of y'all watching, you might think, well, that might make sense because, if someone has been here a long time, they should have all the documentation ready. Now, to some of y'all watching, you might think, well, that sounds reasonable. If someone's been here for a long time, then you'll have all the documentation ready. I wish that was true. After many years, almost 10 years representing clients, it takes clients quite a while to gather everything. If someone were to ask me if I were the immigrant facing a situation where I was in immigration court and I had to provide 10 years worth of evidence that I've been here in the country, that'd be quite difficult. Of course, for us, our law firm, we do provide our clients a checklist, but it takes time for our clients. They do have to work. They do have to take care of their family. That's part of our offer as a law firm, to help our clients, guide them step by step so nothing is forgotten, because every evidence is important as part of their case and their strategy. Now you might ask, what's the expectation? What is the norm so far in the recent past? And that is if the initial court hearing, consider like a pretrial, we call it master calendar hearing. If that was January 1st of 2020, and just not thinking about the pandemic situation, court hearing, the final trial could be a year or later. In some cases, because of the backlog, there's actually up to 1.2 million cases. And so that could be even 2 years later. Court manual that we rely on, it only requires the evidence to be provided 15 days before the trial date. So potentially you have at least a year to prepare everything. Now, internally, I do ask my clients to provide all the evidence really as soon as possible. We just have a trickle flow effect because, if the easiest one, I think, is the tax returns, for example. But in terms of getting friends and family write letters, that takes time because everyone's busy. Here's the other reason why having the documentation and evidence of relief within 3 or 4 weeks is really a burdensome situation, because there are people who are unaccompanied minors, children who are under 18, who may not have access to a lawyer, let alone someone who's an adult that can take several weeks to a month to find a lawyer and hire someone. And that's assuming that person even has the funds to do it. So there's, of course, many nonprofits that are helping people who are unaccompanied minors, because who can expect that they have money to hire a lawyer? So access to an attorney is critical. Related to immigration, there is no public defender. There's no free lawyer, not like for criminal cases on a state or county level. Okay, so what happens if you don't have that documentation? The judge will order you removed because they want proof that you're eligible to stay here, right? It's not a final trial But they can also say that they use the word precluded, because if you don't provide some XYZ documents by a certain date, the judge will say, put an order, sign an order, and say that because you haven't provided this documentation, you've been precluded from applying for that benefit, and also you've been order removed. And so that's a very drastic, severe punishment for a situation when judges are asking for documentation within 3 or 4 weeks of the first court hearing. Now, of course, as a practitioner, as an attorney, we have to do our best to argue certain case law, to argue that we want a continuance, a new court date that allows us more time. But with these rules from the Department of Justice, this will be very difficult to maintain a status quo. So with that being said, if you know someone who has a court date coming up, advise them, warn them that they need to consult with an immigration lawyer. And in fact, I highly recommend, of course, I'm biased as an attorney, but I do highly recommend hire an attorney, because we will organize, at least our law firm, we have checklists, we have guides A through Z, so you feel more comfortable. Anytime you have questions, we're here to answer those questions, and we answer them in a timely manner so that you're not confused about something and it throws you off for a couple of nights sleep. We really want to make sure that you are aware of everything going on. Earlier, I mentioned that the immigration court is housed under the authority of the Department of Justice. And this is important because any rules that the Department of Justice wants to implement through the Attorney General to the immigration court, it can easily be done, as we've discussed with Jeff Sessions earlier this year, and also current Attorney General William Barr. In general, federal district courts and circuit courts, they're under what we call Article 3 courts. So they're independent. So there's equal justice, there's fairness there, as opposed to immigration court. Most people think of immigration court as being unfair, and it is true. And so with that being said, November 3rd, there was an agency decision that basically ruled that immigration judges cannot have their own union. They cannot unionize because they're considered management officials. And what does this really mean? Immigration judges are left vulnerable to political influence, as you can tell from the past 4 years. Thank you very much for tuning in all the way to the end. My name is John Ting, your host. Please hit subscribe down below if you're new to our channel. Hit the like button so you let us know that you've enjoyed our content. And also, please share the video to your friends. Join our Facebook group, Immigrant Guide and Support. All the links that I've mentioned is down below, so check that out. Until next time, please wear your mask.